Tes tes. I hope you can see and hear me. Are you able to hear me and see me?
Yes, Prof.
Oh, good.
Wait a second.
Sure.
Test. Is my sound audible?
Yes, it is.
Okay, thank you. How are you today? Hello?
Yes, I'm
Yes,
here.
I'm here. Okay. Test. Hi, Prof. How are you today?
I'm just fine, thank you. I hope you're good.
Okay. What time in your country?
It's 9:02 a.m. in the morning.
Oh, okay, okay. Because Indonesia right now is night at 11. Wait, wait.
Seminggu sebelum.
Okay, let me start the session. Assalamualaikum warahmatullahi wabarakatuh. Shalom, Om Swastiastu, Namo Buddhaya, Salam Kebajikan. Pertama, saya ucapkan terima kasih kepada BEM Visip yang sudah mau mengundang dan membuat acara webinar internasional ini. Sebelum acaranya saya mulai, akan ada sambutan dari Bapak Dr. Umar Sohaluddin, Sarjana Sosiologi, Magister Sosiologi, selaku Wakil Dekan. Kepada Bapak Dr. Umar Sohaluddin, disilakan.
Oke, terima kasih moderator. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Selamat malam, good night. Salam sejahtera bagi kita semua. Good night, Prof. Donat.
Good morning or good evening, as the case may be. Selamat malam.
Yeah. Their morning. I need to meet you, Prof.
Pleasure to meet you too.
Ya. Terima kasih. Marilah kita panjatkan puji syukur kehadap Tuhan Yang Maha Kuasa yang telah memberikan kesehatan kita semua, sehingga pada kesempatan yang sangat-sangat luar biasa di malam hari ini dan pagi hari di waktu Amerika, kita bisa bertemu dengan salah satu tokoh yang luar biasa, dengan karya-karyanya luar biasa, yaitu Profesor Donat F. Horowitz. Selamat datang, meskipun lewat online. Semoga suatu saat nanti bisa datang ke Indonesia. Coming in Indonesia, UWK, Universitas Wijaya Kusuma Surabaya. Semoga dengan kesempatan ini kita bisa mengikuti satu seminar politik ini. Dan ini sangat luar biasa acara yang digagas oleh Badan Eksekutif Mahasiswa. Dan sampai hari ini, sampai detik ini, the participation sudah mencapai hampir 100, ya, sudah 100, luar biasa. Animo dari para mahasiswa untuk mendengarkan pikiran-pikiran dari Profesor Donat L. Horowitz. Dan saya pikir Profesor Donat adalah seorang ilmuwan, ya, ilmuwan Amerika. Saya kira kalau saya lihat karya-karyanya itu sudah layak dijadikan sebagai Indonesianis. Indonesianis, karena salah satu buku yang cukup menarik yang saya baca adalah Constitutional Change and Democracy in Indonesia di tahun 2013. Saya kira ini cukup menarik untuk kita bahas, dan tema pada hari ini terkait dengan prasyarat demokrasi dengan melihat perspektif Indonesia. Saya kira pas dengan narasumber Profesor Donat ini. Yang pertama. Yang kedua, saya mengucapkan banyak-banyak terima kasih dan hormat yang luar biasa kepada Profesor Donat yang di kesibukannya bisa bertemu dengan teman-teman di Badan Eksekutif Mahasiswa Fakultas Ilmu Sosial dan Ilmu Politik Universitas Wijaya Kusuma Surabaya, Indonesia, untuk saling belajar tentang politik, dan khususnya adalah politik Indonesia. Seperti kita ketahui, di Indonesia hari ini, saat ini telah menyelesaikan the election, ya, dan sudah terpilih presiden dan wakil presiden baru yang dalam proses politiknya itu penuh dengan kontroversi. Saya pikir Profesor Donat mengikuti dinamika politik di Indonesia, khususnya Pilpres 2024 yang penuh dengan kontroversi, mulai tahap awal sampai tahap akhir, gitu ya. Dan putusan terakhir Mahkamah Konstitusi kemudian menetapkan pasangan Prabowo Gibran menjadi presiden dan wakil presiden 2024-2029 yang penuh dengan kejutan dan penuh kontroversi. Saya kira ini bisa dicermati oleh Prof. Donat bagaimana dalam konteks demokrasi kita, demokrasi Indonesia. Apakah demokrasi kita hari ini dalam kondisi yang baik-baik saja, atau mungkin demokrasi kita ada masalah ya, ada masalah, atau mungkin mengalami kemunduran dengan berbagai fenomena-fenomena politik yang hari ini kemarin kita saksikan gitu ya. Dan yang kedua, kita nanti di Desember 2024, tanggal 27 Desember, kita akan melaksanakan pilkada secara langsung serentak seluruh Indonesia, 38 provinsi dan ratusan kabupaten kota akan melaksanakan pemilihan kepala daerah secara langsung gitu ya. Dan dinamika saat ini masih saya sangat dinamis. Dan saya kira ini menjadi momentum bagi kita bagaimana masa depan demokrasi ke depan pasca pemilihan presiden, pemilu 2024 dan pilkada 2024 akhir tahun ini. Saya kira ini menjadi pembicaraan yang sangat penting dan kita akan mendapatkan satu pemikiran-pemikiran yang luar biasa dan perspektif yang luar biasa dari Profesor Donat yang memiliki pikiran-pikiran politik tentang Indonesia, tentang demokrasi di Indonesia. Nah, kita akan melihat bagaimana perspektif Prof. Donat dalam melihat demokrasi di Indonesia dengan menggunakan kacamata beliau sebagai seorang ilmuwan Amerika yang saya kira bisa saya sebut sebagai seorang Indonesianis gitu ya, karena mampu melahirkan karya-karya yang berkaitan dengan politik dan demokrasi di Indonesia. Yang terakhir, semoga seminar ini membawa pencerahan bagi kita semua, bagi para mahasiswa dan semuanya, dan membangun kesadaran kita untuk lebih memahami dinamika politik Indonesia hari ini secara lebih kritis gitu ya, lebih kritis. Dan akhirnya saya mengucapkan thank you very much for Profesor Donat atas for coming here. Semoga ini bisa memberikan pembelajaran bagi kita dan pelajaran politik dan bisa bermanfaat bagi mahasiswa dalam mengembangkan keilmuannya di kampus dan di tengah masyarakat. Semoga ini bermanfaat dan semoga seminar internasional ini bukan yang pertama dan nanti berikutnya ada seminar-seminar lain dengan tokoh-tokoh politik, ilmuwan-ilmuwan politik internasional yang lebih menarik. Terima kasih atas perhatiannya teman-teman sekalian. Sekali lagi saya mengucapkan banyak terima kasih. Thank you very much Profesor Nat yang hadir di media ini, di seminar ini. Semoga seminar ini bisa berjalan dengan baik dan memberikan kemanfaatan bagi kita semua. Demikian akhirul kalam, bila taufiq wal hidayah. Assalamualaikum warahmatullahi wabarakatuh.
Okay.
Oke, terima kasih banyak Bapak Dr. Umar. Okay, let's get started. Before we start, let me introduce myself. My name is Zakaria Alvan Radera, or you can call me Alvan, and I am the moderator of the session. But before we start the presentation, I'm going to read the curriculum vitae of Professor Donald L. Horowitz. Okay, name is Donald L. Horowitz, is the James B. Duke Professor Emeritus of Law and Political Science in the Duke University and PhD Political Science in the Harvard University. And academic career, first, visiting professor in Chicago Law School, visiting professor Central European University, 3, visiting fellow Wilson College, Cambridge, visiting fellow Law Faculty, University of Canterbury in New Zealand, 5, visiting fellow University Kebangsaan Malaysia, 6, visiting fellow academic icon University of Malaya, 7, distinguished visitor political science National University of Singapore, 8, distinguished visitor Nanyang Technology University, 9, visiting research professor Center of Asian Legal Studies, National University of Singapore. And the last is Centennial Professor, London School of Economic and Political Science. And the publication, first, The Courts and Social Policy. 2, The Bureaucracy. 3, Co-op-Theories of Officer Motives. Sri Lanka in Comparative Perspective. 4, Ethnic Groups in Conflict. 5, A Democratic South Africa, Constitutional Engineering in Divided Society. 6, The Deadly Ethnic Riot. 7, Constitutional Change and Democracy in Indonesia. 8, Constitutional Processes and Democratic Commitment. And the last is Electoral Reform and Democracy in Malaya. Okay, now I'm gonna talk to Professor Horowitz because the floor is yours.
Oh, thank you very much, Zakari. I really appreciate it, and it was a very nice warm welcome by Dr. Omar as well. I hope you all don't think that I do nothing but spend my time on airplanes after that curriculum vitae. I've been at a lot of different places, but one of the places I've enjoyed most is being in Indonesia. It's very kind of you to invite me. I really appreciate the invitation. It's always a pleasure to be in touch with Indonesia, if necessarily virtually on this occasion. I prepared a text for this important seminar because the subject is very important, and I'm going to stick very closely to my text so that I finish on time rather than go over time and deprive you of time to ask me questions or enter comments. I should say that for more than 15 years, from about 1998 to 2013, when this book, which I'm showing you now, which I suppose some of you may have seen, when this book was published first in English and then in Indonesian on constitutional change and democracy in Indonesia, I was a close observer of Indonesia's politics, and especially its constitutional politics. I spent an awful lot of time at the MPR observing the constitutional process. And I was and I am a big admirer of the way Indonesia made its constitution. Most people inside Indonesia and outside as well were very skeptical at first that the MPR would be willing and able to do a thoroughgoing renovation of its institutions to produce a democracy in Indonesia. But they were wrong to be skeptical. Indonesia made very great progress during the period of 1999 to 2002. Consider the achievements. The arbitrariness of the Sukarno and Suharto regimes is mostly gone. The military domination of the society is gone. The mass violence of 1966-67 and of the transitional period around 2000 in places like Maluku and Poso, those are also gone. These are giant steps forward, but at least as far as I can tell, and I repeat that my attention has been less on Indonesia than it was a decade ago, there is still more democratic work to be done, and that's what I'm going to concentrate on here, really on not what's right with Indonesia, but what still needs improvement. In spite of all the obstacles, the MPR invented a consensus-driven process, and that's the most important aspect of it. It was driven by consensus, not by compromise, not by voting. And in a more recent book, actually, which I have here someplace, called Constitutional Processes and Democratic Commitment, which perhaps you can see here, I have gone a step further with the Indonesian process. And I followed similar processes in Tunisia and in India in constitution making, and developed a more precise explanation for why that consensus-based procedure worked in Indonesia. But now, at some level of interest, I follow quite a lot of countries, and I'm on to other subjects, a book on federalism, regional autonomy, and ethnic conflict. And I'm still paying attention to Indonesia, but in a much more limited way. So I feel less qualified to provide a detailed expert evaluation of Indonesia's democracy at the present moment, but I'm going to try and do so, at least as far as the basic outlines are concerned anyway. Maybe there's a hidden advantage in having a little bit of distance from a country that you feel so kindly toward. It allows me to concentrate on a few major themes and avoid some specialized details. I'll let you be the judge of that, but please bear in mind that I'm mostly working on other countries now, so I beg your indulgence if you find some defects in my presentation. Let me begin with a basic distinction. Every democratic constitution needs to contain provisions regarding two different types of institutions and their functions. The first types of institution are the popular institutions, the ones that relate to the collectivity of people as they constitute and operate their government and make their demands and requests felt. The political parties and the legislature and also the executive. Now, these are all not just popular institutions, but they're also, of course, correcting institutions because they balance each other out in a certain way, or they should do so. I'll say more about that as we go along. The second kinds of institutions are the constraining or checking institutions, those that assure that the rights of the people and of individuals are not trampled by the popular institutions as they control the governmental bodies. And by the constraining institutions, I mean the courts and sometimes the various commissions and departments that are assigned the job of ensuring regularity and lawfulness, like the KPK, for example, and preventing abuse. So, am I being heard all right? Is everything okay on the technical side? How are the popular institutions doing? The parties, the legislature, and the executive. Well, elections in Indonesia have been generally fair. There have been no hitches in the transfer of power. It's been peaceful on every occasion. But when 83 or 82 or 83% of the political parties in parliament are in the president's cabinet, something is missing. That is a competition of ideas and representation. Yes, the parties compete, but then they sign up to join the government after the fact. Most of them do in any case. A lot of this has to be explained by the attractiveness of material rewards, the foundations and other sources of patronage that are present in the ministries. That is, if you control a ministry, your party gets the benefit of what the ministry has to offer in terms of material rewards. And this gives the president, it seems to me, too much power, because he or she can decide to pull a party into the government or kick a party out of the government whenever it seems appropriate to do so. And the result is a legislature that's supposed to represent the people, but has to yield to the president. And also, there's much less difference in the policy preferences of the parties once they get into government than you might guess just by looking at the composition of their supporters. If you look at the party system in Indonesia, it has quite a wide array of supporters. Each party has a distinctive base of support. And yet, in government, a lot of that really disappears. There's a shortage of policy choices and a high degree of executive domination of the system. This relates to a different critique that could be made of the constraining institutions, the segments that the courts, the commissions, and so on. The segments of the society can be mistreated by the executive and have no one stand up for them in the legislature because there's insufficient opposition. This would not be so important if the constraining institutions were doing their job well, but several are not. And especially, I want to single out two that really don't seem to be doing their job very well. And I have in mind here the Constitutional Court and the Supreme Court. The result is that certain religious and ethnic minorities in Indonesia do not have judicial protection they should enjoy, and there are many other problems that result from the poor performance of the two courts that I just mentioned. The Constitutional Court, after a fine start in the early 2000s, has slipped noticeably. Let me cite some decisions, and I have 4 decisions I want to point to, which I think are real failures on the part of the Constitutional Court. First of all, is the blasphemy case that held that the 1965 Sukarno-era criminal penalty for blasphemy was consistent with the Constitution. That decision was rationalized in a public statement by the then Chief Justice as designed to prevent vigilante justice on the streets against those accused of blasphemy. The Chief Justice said, look, isn't it better to have a judicial proceeding than to have mobs chasing people who are accused of blasphemy? Much better, he said, to have the courts adjudicate accusations of blasphemy. Instead, the Chief Justice got both. He got an upsurge in vigilante activity, including crowds pressuring and threatening the courts themselves if they were dealing with blasphemy cases, and a great upsurge in blasphemy prosecutions. There are many, many more now than there ever were under the Sukarno and Suharto regimes. In a democratic society, it's very questionable whether there's any place for a prohibition on blasphemy in the first place, unless it's accompanied by violence or the threat of violence. But in any case, these prosecutions have made religious minorities less secure. They're vulnerable to fake accusations and to blackmail, and the courts are vulnerable to implicit and explicit threats of violence if they don't convict the accused defendants. That's not the only place that the Constitutional Court has fallen down. Another example relates to some regulations issued by Daira and Kota, often relating to religion, but not just religion, over which they have no jurisdiction. The Home Affairs Ministry was at first very slow to review those illegal regulations, but it picked up the pace some years ago after the 2014 law on autonomy, because it was authorized explicitly in that law to check the regulations, depending on whether or not the governor of a particular province had approved or vetoed the regulations. And so that statutory authorization in 2014 was quite a considerable grant of new powers to review provincial decisions on local regulations and to cancel regional regulations that had not been vetoed by the governor. The advantage was that it could do the job quickly. For a great many, I'm referring, when I say it, I mean the Home Affairs Ministry could do the job very quickly for a great many ultra vires laws. By ultra vires, I mean not authorized laws that were of the same kind. But when this was challenged in the Constitutional Court held that this was a judicial function and it was one that was confided to the Supreme Court exclusively, which therefore could not be performed by the Home Ministry. One could have imagined, by the way, that the Home Ministry's decisions could be challenged in the Supreme Court. That would be a different matter altogether. But the Constitutional Court decision took away the jurisdiction of the Home Affairs Ministry to review regional regulations. And the Supreme Court, which was supposed to have been reformed after the constitutional changes of 1999 to 2002, but never was, has been vulnerable to corruption and lethargy as well, not merely corruption, but inaction. It has left many challenges to unlawful local regulations utterly undecided for years. That Supreme Court was declared by the Constitutional Court to have the exclusive power to review those regulations one at a time. Remind you, the Home Affairs Ministry could have reviewed them not one at a time, but multiple regulations of the same kind at one time. Now, if you're wondering why Indonesia started out with 348 regions under the autonomy scheme at the beginning, when devolution was first approved early in the reform process, but now, when I last looked, it had 514 regions, and I'm not sure that number is still correct. But it went from 348 to 514 and maybe more now. I'm just not sure about that. It's largely because the central government never figured out how to regulate conflict within the regions. When I say conflict within the regions, I mean both religious conflicts and claims of putra daerah. That is to say, some groups claiming that they were indigenous to the region and had superior ability to govern and to exclude others. These caused great conflicts within the regions early on in the devolution process. But instead, parties, instead of regulating these conflicts, political parties took the opportunities they were given by the requirement of parliamentary approval to help split regions and to advocate splitting them rather than conciliating conflicts. Each part of a split region now is usually, oops, I'm sorry, I apologize for the telephone. My wife will grab it. Each I hope she'll grab it. Each part of a split region is usually ethnically or religiously homogeneous now. And there was an opportunity missed to find ways of living together and to have a more manageable number of regions than the current number is. We have, by the way, 3 studies of the splitting of regions, one by Risa Toha, another by Jan Pirskala, and another by Bazi and Gujan. They're 3 good studies. They all reached more or less the same conclusion about the process of splitting regions in which there had been conflicts before. But there would have been a much more manageable number of regions had there been the ability to work on conciliation within them. Now, 2 more constitutional court decisions. One of them is mystifying, absolutely mystifying, and another is, it seems to me, just plain wrong. You'll forgive me if I'm very blunt about my criticism, but it would take, if I said it in more polite language, it would take me twice as long. So please bear with me if I perhaps react strongly to some of these decisions. You'll remember that Megawati was supposed to be favorable to the interests of minorities, but when she was president, she proved to be the opposite when she divided Papua into 3 regions, which were not authorized by the original autonomy statute. This was challenged in the Constitutional Court, which decided, as I say, in a mystifying decision, that her action was unlawful, but for some unfathomable reason could not be reversed. This is an odd bit of reasoning on the part of the Constitutional Court. Jokowi has followed in Megawati's footsteps on Papua, dividing it now into 5 regions. The army is very keen on this division because it likes the idea of doing mining in regions in which it has a more hospitable government. Whether that's the operative cause of this change, I don't know. But there's no doubt that this pleased those who run the economic business of the army in Papua. Kustur, for all of his failings as president, was much more conciliatory toward minority interests and more likely to have been able to reach a decent settlement with the Papuans than Megawati actually did. The other egregiously wrong Constitutional Court decision concerns the electoral system. You'll recall that Indonesia's constitution and especially its proportional representation electoral law provided for closed list proportionality. By the way, I said constitution, it's the electoral law, not the constitution, provides for closed list proportional representation. This was challenged, and the Constitutional Court decided that lists had to be completely open, which means that candidates on the list from the same party, even though they start out on the list below other candidates, can move up on the list and end up on top of the list rather than lower down. That's because they get votes for them as individuals. That's an open list system, and the Constitutional Court declared that the lists had to be completely open, which produced competition between candidates of the same party and lots of vote buying by them. The vote buying wasn't a very prominent aspect of electoral politics early on in Indonesia's democratic dispensation, but it's apparently very great now. We have a good study by Burhanuddin. I've forgotten his bin, but the study shows that vote buying is now much more widespread, and that's exactly what you would expect when open lists are substituted for closed lists. Closed lists may or may not be the best electoral system, but they are used in many democracies and can hardly be said to violate constitutional provisions regarding the right to vote. Indonesia's Constitutional Court is the only court that I know of to have declared them unconstitutional. Well, I hope this provides an idea of the erratic, unpredictable, and ill-considered decisions of the Constitutional Court, and with less specificity, the inert and poor performance and non-performance of the Supreme Court, which was supposed to be reformed after 1998, and the occasional or perhaps as of 2022, more than occasional corruption present in both of them. One result of this has been the proliferation of specialized tribunals. Indonesia, for example, is the only country I know of that has a fisheries court to deal with fisheries disputes. And I think a lot of the proliferation of specialized courts of this kind has a lot to do with an understanding of the underperformance of the Supreme Court of Indonesia. I must tell you a little story. I once asked a very prominent Indonesian lawyer, you would recognize his name, but I'm not going to name him. He's no longer with us, in fact. I once asked a very prominent Indonesian lawyer how he prepares for trial in Indonesia. And he replied as follows. He first began to think very carefully, and he was holding his hand to his head to ponder the question. And then suddenly he burst out laughing. And he said, prepare for trial. Nobody prepares for trial in Indonesia. It's just a question of who's going to pay the judge more. This is a terrible indictment of the judicial system, in fact, if it still exists in the same form. Let me just say that Indonesia has what I did call in the book, a rule of law deficit. And anytime an institution like the KPK shows itself capable of upholding the rule of law, legislative action is proposed or enacted to reduce its effectiveness. Excuse me. Now, a few general remarks before I close. First of all, one thing that seems to be missing in Indonesia is that there's no notion of government and opposition. So coming back to what I referred to earlier as the legislative subordination to the president, which was, by the way, definitely not intended by those who drafted the Constitution. And when I say the Constitution, I mean the four amendments from 1999 to 2002, which really changed the basic structure of the Constitution. This was not intended. Witness the initial inclination to have the MPR continue to appoint the president. There was some significant support for that. So the idea, if the MPR was appointing the president, well, you can tell that wouldn't have given rise to domination by the president of the entire system. And some scholars have attributed the presidential domination of the system to party cartels. That is to say, essentially tacit organizations in which parties share power more than they contest power. Rival coalitions tend to dissolve after presidential elections. And the DPR has been engaged in consensus lawmaking, keeping some affected interests out so that they can protect others and giving rise to protests later. You get very strongly oversized cabinets with no serious opposition or very little serious opposition or accountability of cabinet behavior to the legislature. This is a failure of a checking institution. There's recurrent lack of opposition that can be a serious flaw in governance because it allows those in power to do what they wish without fear of lawful restraint. There are also norms of fair distribution among parties, which gives rise to complacency more than opposition. So if there's a scandal in one party, the other parties are not going to pursue the scandal to its logical conclusion because they may also be vulnerable to accusations of scandal. And so there's a lot of collaboration in covering up malfeasance, collaboration among the parties. Indonesia is a big country, a very big country, and the parties need funds to operate. Government largesse can provide those funds. Hence, you get this malfunction. A second reason is and I'm talking about government and opposition here. A second reason is the occasional weakness in party support of a popular presidential candidate. You'll remember that when SBY was elected president, his own party was a very weak one. So he needed an oversized cabinet because he and his party couldn't have governed alone. If presidential candidates were chosen by processes more likely to produce winners with strong party support, governing parties would be less interested in oversized cabinet coalitions. The original intention in the MPR's view was to have a separation of powers regime with government and opposition, but oversized cabinets dim the prospects for a separation of powers regime with government and opposition. During the constitutional process, consensus was the governing norm. And this is perhaps a third, and unfortunate byproduct of the constitutional process. That is, consensus was the governing norm as the new constitution was being developed. And you notice I call what is still called the 1945 Constitution a new constitution. It is essentially a new constitution. Now, there was a fear of polarizing between secular and religious forces in the initial sessions of the MPR. So there was a serious attempt, which proved to be successful, to understand each other's positions and to cooperate in constitution making and to do nothing until everybody was agreed. This, unfortunately, has carried over into normal politics, where it's not so functional to democracy, which really requires some degree of opposition and criticism of government action. And a fourth cause for the current malaise, well, I call it malaise, a fourth cause for what I think it's fair to call a certain amount of dysfunction, is that these interlocking features produce an underdeveloped system of governing through coalitions and opposition. There's real discontent with an incompetent government could break the cartelized system apart if it became very unpopular. So far, ideological decisions have not supplanted self-interest in the search for coalitions opposed to each other. And finally, coming back to the rule of law deficit, this creates a great many dysfunctions: a lack of legal predictability, expanded corruption, less than optimal punishment for violent behavior, and perhaps most important, a parallel deficit in minority rights and for religious and ethnic groups. For Christians whose church building permits take forever to get approved, for Shia and Ahmadis who are routinely persecuted, and for Papuans whose separatist movement could probably have been blunted far more effectively by a devolution regime as generous as Aceh's than by the deprivation of the current devolution regime. Just think of what might have happened if Papua had a devolution regime as generous as Aceh's. Okay, now I don't mean to sound too harsh, although I'm sure this does sound very harsh. I think Indonesia has the capacity to build on its constitutional foundations to do much better in its politics than it has so far. It has two very big advantages. It had an enormous success to its credit in ridding itself of an oppressive former regime, and it could probably pull off another successful reform if the impetus to reform were there. And second, its flaws are not hidden. They're obvious, they look serious, and they're easily ascertained by any inquiry that the public cares to make into them. They look serious, but they are by no means fatal. These are reformable problems, not unreformable problems. Another interpretation, by the way, of the similar phenomena, I want just briefly to touch on another interpretation of the same phenomena, has recently been advanced by Leonard Sebastian and Yanwar Aditya Pratama at the Rajaratnam School in Singapore. And it's that Indonesia's democracy is not liberal democracy, it's keluarga democracy, familial democracy, in which it is best not to have a disruptive opposition. Like a family, the country needs to be united. Prabowo has been co-opting Nasdem and PKB into his coalition and hoping for only a soft opposition that doesn't really oppose. In this view, government takes care of the family, and the family has to be grateful. Maybe that is correct. I'm not so sure myself, but let me put it a little bit differently. Every country has some distance between what the public believes about its fundamental law and what its framers intended and the lawyers understand it to be. But Sebastian and Janwar are describing something like a very wide gulf between the public understanding and the initial understanding and construction of the constitutional regime. If that's correct, it marks a return to earlier versions of Indonesian regimes, with only the exception of competitive elections, because they were not really present at any point before 1999. Well, they were, yes, there were at one point, and you remember there was great disillusion with the extent of the rotating governments that occurred when elections during a very brief period of real electoral democracy, when governments were alternating and shifting every few months. But the earlier version of the Indonesian regimes that Keluarga democracy might represent is not the kind of democracy that the drafters of the Constitution created between 1999 and 2002. I hope it's not right. I hope it's that Indonesia's gap between the popular understanding of democracy and the intended democratic regime that was drafted between 1999 and 2002. I hope that I'm not right, that the gap is as wide as that view thinks it is. And I'd welcome some education from you on whether you think it's that wide as well, or whether you think I'm just very far off base in describing things as I have. Thank you very much for listening so attentively. I appreciate it. And I welcome any questions that you might have, or any objections that you might have that would help to enlighten me further.
Okay, thank you very much, Professor Horowitz, for the insightful presentation. It turns out that Professor Horowitz researched a lot about democracy in Indonesia and read a lot of books to find out. And even the professor knows a lot about government in Indonesia. And from the discussion earlier, explained a lot about history, democracy in Indonesia, political in Indonesia, and legal system and rule of law in Indonesia. Oke, jadi banyak sekali yang dibahas oleh Profesor Horowitz. Bahkan Profesor Horowitz ini tuh meneliti banyak sekali tentang demokrasi di Indonesia dengan membaca buku dan bahkan membuat buku sendiri untuk mengetahui sistem demokrasi di Indonesia. Nah, dari demokrasi dari pembahasan tadi, poin-poin yang dijelaskan oleh Profesor Horowitz itu banyak sekali tentang histori demokrasi dari Indonesia tahun ke tahun, lalu dari evolusi politik Indonesia dari masa kolonial hingga ke reformasi, bahkan sampai keterbukaan politik dan masyarakat sipil. Di poin terakhir, Profesor Horowitz juga menjelaskan bahwa di Indonesia itu juga mempunyai tentang kelebihan mengenai pemerintah Indonesia. Salah satu contohnya mengenai ketika ada demokrasi, ketika ada demo, pemerintah Indonesia itu nggak diam aja. Pemerintah Indonesia itu mendengarkan apa yang didengarkan oleh rakyat. Salah satu contohnya seperti itu. Okay, now we're gonna in the question and answer session. To everyone who wants to ask to Professor Horowitz, can chat below in the chat box. We just had 2 questions for Mr. Horowitz. To everyone who wants to ask, can chat in the chat box in the below of the video. Or maybe we are more appreciate if you are asked turn on your video and turn on your mic. Jadi buat seluruh peserta yang mau bertanya boleh langsung ketik di kolom chat, karena ada 2 pertanyaan yang akan dijawab oleh Profesor Horowitz. Kita lebih concern kalau misalnya kalian tanyanya secara langsung, maksudnya secara membuka video dan juga menyalakan mikrofon. Tapi kalau misalnya nggak mau juga bisa dilewat di chat box saja. Okay, there is a question for Arya Giri. Apa yang terjadi ketika demokrasi sudah tidak berjalan di Indonesia karena tanda-tandanya sudah sampai sekarang? So the question is, what will happen when democracy no longer works in Indonesia because the sign is now visible?
Because, what did you say?
Because the signs are now visible.
Oh, I see. You mean the signs of decline. I get the idea, yes. Look, I think that as long as there are democratic elections in Indonesia, and that's the one thing that Indonesia has done rather well on the whole. Whatever you may think about the way presidential candidates are selected and coalitions form around presidents, the inter-party legislative elections are democratic. There will be at some point, there will be some incentive for some party to say something's wrong here. So I think that a lot of the corrective institutions are not doing well, but the electoral process for the legislature is doing fairly well, and that is some kind of check on the really precipitous, the really great decline that you might imagine Indonesia could be vulnerable to. I mean, one could get a little bit more personal, talk about the recent selection of the president and what that suggests, and I think that doesn't necessarily bode so well for Indonesia. But despite that, an attempt by the president, for example, to capture all power, I think would be resisted in the legislature, even if the legislators are mainly already in the cabinet. But who knows? I'm not very good at making predictions, and I'm certainly no better than anybody else at making predictions, and I don't really know what would happen in case of a real crisis. But my own suspicion is that there would be some corrective forces that would arise in the civil society, but even more in the political parties represented in the legislature. I'm not hearing anything. If somebody is saying something, I'm missing it.
Okay, sorry for the connection is unstable right now.
Hmm.
Okay, so there is a next question by wait. There is another question. So, what is the appropriate form of democracy in Indonesia, as conveyed by Bung Karno at the beginning of independence, where culture is benchmark, or how?
I mean, could you give me the last few words again?
Okay.
After Bung Karno.
By Bung Karno at the beginning of independence, and where culture is the benchmark, and
Well,
how?
culture is the benchmark.
Yeah, when the culture
Yes.
is benchmark.
Yes. Well, what I want to say is, look, if that were the case, if Bung Karno were right that Indonesia needs a certain kind of limited democracy because of some features of its culture, then one can't explain what went on between 1999 and 2002 in the MPR. That is to say, one can't explain the drafting of the new constitution, because that constitution, yes, it made some acknowledgement of various aspects of Indonesian culture, but it's also the case that what was drafted was a constitution in most ways very much in line with other constitutions of the world. And it was drafted not by some narrow group of people operating inside the MPR, but by a very large consensus of all of the parties in that body. So I'm not so sure that Bung Karno was right in saying that the Constitution of Indonesia that he preferred reflected the pre-existing culture of Indonesia so much as it tried to shape the culture of Indonesia. I'm not sure that Indonesia is as different on that score as was claimed at the time. I mean, we could get this discussion on that particular point, and it's a very important point. I think that we could get that down to much more serious details if we could specify more what that culture consists of and why it was so compelling, why it's still compelling, and so on, as opposed to just simply looking at some of the structural features, such as the fact that parties need money in order to operate. Political parties need funds. And so they enter government in the hope of collecting funds so that they can continue to operate. It's a kind of circle that they're involved in. They need funds, so they go and get funds, and then they go and spend funds, and they need funds, so they go and get funds, and so on. So, I mean, some of these structural features seem to me every bit as important as the cultural features. But I could be wrong about that. I'd love to see a further discussion of that point with details about what it is about Indonesian culture. Yes, it's consensus oriented. I agree with that. That's for sure. On the other hand, Indonesia's had plenty of conflict. It's not all consensus. And so one has to ask why one part of it should dominate over another part of the cultural features in the operation of Indonesian politics.
Okay, what a great answer from Professor Horowitz. Maybe there is another question to the all participant who want to ask to Professor Horowitz can chat in the chat box. Right now. Okay, there is another question. Okay. Okay, there is one question for Intan Nurwahyuni. Is there a difference between democracy at the national level, especially in your country and regionally in Indonesia? If yes, what is the cause?
Oddly enough, you're asking me to be an expert on American politics, which I'm not really. I could tell you a lot more about Malaysian politics or Sri Lankan politics than I could tell you about American politics. It's not, though I'm an American citizen born and raised here, it doesn't make me a great expert in American politics. If I told my colleagues in political science that I'm an expert in American politics, they would laugh. But I will try and answer. American politics consists of a very considerable balance among the various branches of government. So the Congress, the legislature, which consists of two houses, two equal houses, by the way, the Senate and the House of Representatives pass the laws, and they also oversee the administration. That is to say, they check and balance the administration. I don't mean to say they supervise it, they don't, but they are able to review the administration and to take away budgetary authority from institutions in the administration that they disapprove of, or revise their authorization to go forward and to perform their tasks. The legislature has a lot of power in our system. So does the president. But the president cannot, for example, expend funds that the legislature has not authorized and appropriated. So that's a very important power for the legislature to do. Then we have a very powerful court system, which can declare acts of Congress, that is to say, acts of the federal legislature, unconstitutional, can declare acts of state legislatures unconstitutional. And of course, we have a federal system where the states have very much more power than your daira have, because yours is a regional autonomy regime rather than a federal regime. And you know, of course, that early on that federalism was proposed and was eventually in Indonesia was shouted down very early on in 1998, 99. But the United States has got a system of checks and balances that's quite robust, and it more or less, well, it doesn't work perfectly, that's for sure. President Biden has spent some funds that were not appropriated by Congress, and Congress has gotten rather upset about that. So it's got a lot of presidential power, a lot of legislative power, and a lot of judicial power. All three powers checking and balancing each other, and that's what I think is more or less out of balance in Indonesia. There's a lot more presidential power than was intended in 1999 to 2002. But other countries, well, other democratic countries have very different ways of apportioning power. Parliamentary systems do so through the legislature. The executive comes out of the legislature rather than from a president, because there is no president in a parliamentary system. There's merely a prime minister who represents, in most cases, the majority party or a coalition of majority parties. So that's the story. There are many books, by the way, on comparative politics, which could explain this much better than I can in a short time.
Okay, thank you very much, Professor Horowitz. Jadi tadi kan Mbak siapa ini? Mbak Intan Nurwahyu ini kan bertanya mengenai perbedaan demokrasi yang ada di Indonesia dan juga di Amerika. Nah, jadi Profesor Horowitz ini tuh sebenarnya nggak tahu banyak mengenai demokrasi yang ada di Indonesia maupun di negaranya sendiri. Karena kan memang bukan dari pemerintahan juga, tapi ada beberapa poin yang disampaikan oleh Profesor Horowitz ini bahwa Amerika Serikat itu juga menganut sistem presidensial yang sama, namun juga memiliki federal yang kuat, lebih kuat, maksudnya lebih powerful lagi lah. Lalu dari pemilihan umum, dari pemilunya juga itu diadakan setiap 2 tahun untuk memilih anggota DPR-nya di presidensialnya Amerika, seperti itu. So there is a last question, Professor Horowitz. So the last question is, in Indonesia, we just had election. So what do you think about the election in Indonesia, especially in 2024?
Well, I didn't follow the 2024 election in any great detail. And to tell you the truth, I was rather disappointed with the result because of the history of the winning candidate. You may know that in 1998, Prabowo was in charge of a unit that was implicated in some violent episodes in Jakarta, which proved to be fatal to a number of people. Some of you will remember the fire in the department store, in which quite a lot of people were killed in Jakarta. So he has a kind of checkered history, let's put it that way. When I say a checkered history, I mean a history that's not, how shall I put it diplomatically, a history that could be subject to a certain amount of challenge. So it struck me as a little bit odd that in a democratic election he could do as well as he had done in Indonesia. He somehow managed to retrieve his reputation. For the rest, nobody is saying in Indonesia that I've heard so far that the election was not well run, that it didn't reflect the view of most voters, that there was a lot of cheating. In every democratic election everywhere, there's a certain amount of cheating. But there was not enough cheating in Indonesia, as far as I can tell, to say that the result was not reliable. What more is there to be said about a democratic election, except that it reflected the votes that were cast, and this one seems to have reflected the votes that were cast, whether or not you or I would have voted for the same candidate had we had the choice.
Okay, that's all, Mr. Donald, Profesor Horowitz. Oke, jadi dari jawaban yang dijawab oleh Profesor Horowitz itu mengenai ini apa? Election, pemilihan umum presiden di tahun 2024. Nah, dari pernyataan dinyatakan oleh Profesor Horowitz sendiri itu sebenarnya Profesor Horowitz itu tidak terlalu mengikuti election yang ada di Indonesia, tidak terlalu mengikuti tentang pemilihan umum yang di Indonesia, tetapi beliau tahu bahwa sempat ada isu mengenai kecurangan yang terjadi di Indonesia, tetapi semoga itu tidak benar dan tidak bisa. Dan Profesor Horowitz ini memohon semoga itu tidak benar agar tidak berdampak pada pemilihan umum di tahun-tahun berikutnya. Seperti itu. Okay, so we just done the session. For me, I'm really very, very, very thank you for Professor Horowitz for the insightful presentation, for the valuable insight. And thank you for everyone for joining us today to listen our session about prerequisite to democracy, looking at Indonesia. And we hope you found this online session informative and engaging. Have a great day. Thank you very much. Good night.
Thank you very much.
Have a great day, Prof.
Thank you. The same to you. Thanks for all of your help with this.
Thank you.
Wong iku, Cuk. Cowok ger. Wong expert tuh, Cuk, botak, Cuk.